Hello and welcome everybody. This is the English explanation of the chapter on property law. This is your Unit 2 of Class 12 Legal Studies textbook. First of all, we need to remember the definition of property. Any interest or right that has an economic value denotes property. And in India, such matters about property are governed by the TPA of 1882, the Transfer of Property Act. It's an uniform and systematic law which transfers immovable property between two or more living persons. That's the introduction to TPA. And we have three types of property: movable property, immovable property, and intellectual property. Movable property can be transferred from one place to another, and in India, such transfers about movable property, it is governed by the Sale of Goods Act of 1930. For instance, jewelry or other such things which can be transferred. Now this chapter specifically deals with immovable property, and if you define immovable property, then any property which is attached to the earth and which cannot be transferred from one place to another can be termed as an immovable property. And we have already discussed the TPA, Transfer of Property Act 1882, deals with the transfer of such immovable properties. And section 3 of TPA states that lands, buildings, and any benefit arising out of lands and buildings, they are to be treated as immovable property. Fruits too fall under the category of immovable property. Then we have another type of property, intellectual property. Intellectual property, they are neither movable nor immovable. Any work of art created by the knowledge and intellectual capacity of a person are termed as intellectual property. At this point, we come to two important case laws. One is Shantabai versus State of Bombay, another is Marsal versus Green. In Shantabai versus State of Bombay, this case was of 1958. The distinction between movable and immovable property was given. A tree is to be considered immovable if the intention is to reap fruits from trees. Fruits are benefits out of trees, and the trees are to be treated as movable property if the intention is to cut down the tree and use it as timber. You see, whenever we cut down a tree, we are using the trunk. Like for instance, to make furniture, we use the timber, or we use the trunk for producing charcoal. In that case, trees are to be treated as a movable property. The next case is Marshall versus Green. It again explicitly mentions that the sale of trees cut and taken away is to be considered movable property. That's it. There is nothing else here. Now, who can transfer property? The criteria. There are 2 points, A and B. Any person who is competent to contract, which in turn includes 3 subpoints. Any person who is above 18 years of age, who has a sound mind, who has a rational judgment, and the person should not be disqualified by any law in force. Alright. The second point is that the person should be authorized to dispose of the property. The person should be the owner of the property, or any other person authorized to sell the property. Such a person can transfer. And the transfer is the person who gives the property, the person who transfers, and the transferee is the person who receives the property. Done? How can property be transferred? Well, the mode of transfer of property depends upon the value of the property. You must write this sentence in your answers. If the property is of the value above rupees 100, the transfer has to be by a registered instrument. We have to legally register the transfer. If the property is tangible as in if we can touch the property. Tangible means something which can be touched. And if the value of the property is less than rupees 100, then transfer needs to be done only by delivery. As I have drawn here the small pictures of mangoes, fruits like mangoes or whatever fruits or any other things sold in the market, they are to be transferred only by delivery. Obviously, we don't register something we buy from the shops. Such things below rupees 100, they can be transferred by delivery. And intangible property, which includes intellectual property like patents, trademarks, designs, or other such things, irrespective of the value. It doesn't matter whether they cost rupees 50 or rupees 1000 or rupees 1 lakh. Any intangible property which are to be transferred has to be transferred by a registered instrument. Then we come to the method of transfer. It includes 4 steps. First of all, registration, which is an essential legal formality. It includes the first step where the parties to the transfer has to attest, or they have to affix their signatures in the documents, and these documents must contain the rights, obligations and liabilities of the parties. All these things are written in the documents. So parties sign these documents, then 2 witnesses will sign. Attestation means nothing but signing. Then 2 witnesses will sign with the intention to be witnesses of the transfer. Last but not the least, after all these things are done, the third thing is that the seal of the registrar office has to be affixed in all these documents, and the document is to be included in the official record. This completes the transfer process. Now there are 6 essentials of a valid transfer which we need to remember. Just remember the key points and it will be good to write the answers. First of all, transfer has to be between 2 or more living persons. You can see these are basic points. You don't require much effort to remember these things. And the second point is that the property should be free from encumbrances or legal obstacles. There shouldn't be any litigation pending on the property. And the property should be of a transferable nature, of course. Transfer should not be for an unlawful object or an unlawful consideration, and it shouldn't involve a person who is legally disqualified to be a transferor or a transferee. Fourth point, the transferor should be competent to make the transfer, entitled to the transferable property and authorized to dispose of the property, just as we have read who are the ones who are competent. Then fifth point, appropriate mode should be complied with. It has to be done according to proper legal procedures like registration, attestation. These things should be done in accordance with law. And in case of a conditional contract, the condition should not be illegal or immoral. Alright? And also we have 2 important doctrines. Let's focus on Doctrine of Election first. What happens in Doctrine of Election? It's there in section 35 of TPA 1882. Now, a party to the transfer, they cannot accept and reject in a single transaction. While claiming advantage, the burden of the instrument has to be accepted. If I give a simple example, suppose I want to buy the farmland or a farmhouse of another person, and the person wants to sell both the farmland and the garden to me. I have to accept both the farmhouse and the garden. I cannot say that I only want to accept the farmhouse and reject the garden, because garden is a liability for me. I can't really maintain a good garden. I only want the farmhouse for my own benefits. I can't do that. Doctrine of Election, section 35 of Transfer of Property Act prohibits that. We have to accept both the farmhouse and the garden, or we can accept none. And in Cooper versus Cooper, a case in English law, the court declared that Doctrine of Election is applicable on all property, on all transfers of property. Okay? Next we come to the Doctrine of Lispendence. It's an important doctrine which is important in your exams too. Doctrine of Lispendence, it states that nothing new should be introduced in a pending litigation. Litigation means settling a issue in court. When it's a formal court proceeding, then it's a litigation. Now see, this doctrine comes from a Latin maxim, ut lite pendent nihil innovator. It means nothing new should be introduced in a pending litigation. What is this saying? In case there is a suit or litigation pending in a court on the title of an immovable property, then the property cannot be transferred. Suppose I am the owner of a property and there is a case pending in the court. I'm so sorry. In this case, I cannot transfer this property because my title of ownership is itself in question. And there are some conditions which we need to fulfill. in order to constitute the doctrine of Lispendence, first of all, the suit proceeding needs to be pending, right to the immovable property should be in question, and the transfer should affect the right of another person. Property in litigation should be transferred. These are the things. You need to read the textbook carefully, and then you need to refer to the notes. I think then it will be clear, much clear. Next we come to the types of transfer. First a sale, then a lease, then an exchange, and finally a gift. You see what happens in a sale. First of all, sale details about the sale is written in section 54 of Transfer of Property Act 1882. We need to remember the definition. You need to remember these 4 keywords. That's it. Sale means a complete transfer of ownership of property, and here the consideration is price. Consideration means something in return. When we give something to another person, we also expect the other person to give us something in return. That's how legal studies work. Alright, in this case of a sale, there is a complete transfer of ownership. When I give something to somebody else in case of a sale, it's absolutely gone from my hand, and the other person becomes the owner of the property, and I definitely get a price in return. There are 5 essentials of a valid sale. First of all, there should be 2 different parties. The parties should be competent. The property which is transferred should be in existence. The consideration should be money, and it should be in accordance with law. The entire process of sale should be in accordance with law. Here we have a case. Madam Pillai versus Badar Kali. In this case, what happened? The plaintiff was the first wife of the husband, Badar Kali, and she made a claim of maintenance. The husband orally transferred land to the wife, which costed rupees 100. Now this is already transferred to the wife. Later he wanted to sell the land to the wife, which already she has got because of the oral transfer. He promised his wife that he will give the land worth rupees 100, but then he said that you need to pay me rupees 100. This is not fair, because I already own the property. You gave me the property almost like a gift in the form of maintenance. Now I don't need to pay for it, but Badar Kali did that. And what the plaintiff did, she initiated a suit stating that the transfer was already done, and the subsequent sale is definitely not valid. But the defendant, now her husband, said that the transfer of property was not registered, and we cannot really say that it was a transfer. That's what the defendant said. But the court's decision was that since the husband gave the land orally to his wife, there was an oral transfer of property, and in this way she acquired a title by way of the oral transfer because of the promise. That's why the wife got her land worth rupees 100. That's it. And here we need to remember, the person who gives something is the seller, and the person who receives is the person to whom the property is transferred. I hope that's clear. Then the next form of transfer is lease. Lease, how do we define lease? Okay, first of all, let's do another thing. You need to do the rights and liabilities of the buyer and seller in the case of sale, lessor and lessee in the case of lease, like this. There is nothing important to explain there. You need to just read it once. See, rights and liabilities doesn't come in the exams. You can write it from me. You just read it. I just want you to be familiar with everything that's there in your textbook, but beyond that you need not pay much attention to rights and liabilities of the buyer and the seller. The next important part is lease. What is a lease? Lease is a transfer of right to enjoy a property for a specific period of time. And here too, the consideration is price. We give price when we want to stay in an apartment, for example. We give rent in that case. Who is a lessor here? The person who lets out the property, and lessee is the person to whom the property is leased, the transferee. And there is a case on Gajadhar versus Rambhai, and this is an important case of 1938. Here the theatre was subleased, and subleased as in what happened? First of all, there is a lessor. which was Gajadhar in this case. He leased the property to some other person. Let's consider A. Now A further leased the property to another person, whom I suppose is Rombe. And Rombe was not allowed to take possession of the property by the original lessor, which is Gajadhar in this case. This is wrong. And it said now that Rombe can sue Gajadhar for infringing his rights to peacefully enjoy the property. Here too you need to read the rights and liabilities of lessor, and the rights and liabilities of lessee is a little lengthy, but I'm sure that if you read it once or twice, you will be able to do it. Exchange. When two persons transfer the ownership of one thing for another, it's called exchange. Here consideration is not money or price, it's simply another property. I give you something, I give you a piece of land, and you give me another piece of land in return. That's exchange. And details of exchange is drafted in section 118 of Transfer of Property Act. If you cannot remember these sections, like section 118 in case of exchange or section 54 in case of sale, don't worry much. These things are generally not asked specifically. And as far as I know, you won't be giving an MCQ test this year in midterm, so you can skip these section parts. But if you can remember, it's better to do it, because you can write answers then. Alright, exchange can also take place by sale. The person who gives the land is the buyer and another person is the seller. It's almost similar to sale. I don't think there is much rights and liabilities of the persons here. And then we have gift. Gift is drafted in section 122 of Transfer of Property Act. Definition of gift: a transfer of ownership of property which is made voluntarily. You must mention the word voluntarily in your answers. Without it, -half will be deducted, as far as I know. And this transfer is done without any consideration. There is nothing given in return. The person who gives the gift is the donor, and the person who receives, the person to whom the transfer is made, is the donee. And if the donee expires before the transfer is made, then gift becomes void. Now, let me give you an example of gift. For instance, when our parents are old, they come to the end of their lives, then they give us much of their earnings, their property, jewelry, whatever land they own, their money, everything. This is gift. Do we pay them in return for giving us all those things? No. That's simply given to us. That's a gift. There is no consideration in the case of a gift. You see how fast we have covered this entire chapter? There is nothing else here. Next we come to intellectual property. Definition of intellectual property is often asked. See, intellectual property is neither movable nor immovable. What happens? Any work created by the knowledge and intellectual capacity of a person is called intellectual property. Like invention, artistic works, literary work, design. These are all examples of intellectual property. Anything that I have created by my intellect. Just remember it like this. It comes from the word intellect. And there are different types of intellectual property: patents, trademarks, copyrights, designs, geographical indications. Let's do it one by one. What's a trademark? Trademark is any mark put on a product so that people can easily distinguish it from other products is called a trademark. A simple example will be a brand name. There are famous brands like Lakme. They're trustworthy brands. Or for instance, Apollo Pharmacy, Titan watches. These are all trademarks. We can easily distinguish other products from these renowned brands. Those are trademarks. They make the products reliable to us. Then we have patents. Whenever you see patents, just remember this is something about invention of products, usually used for medicines and all. Patent refers to the right granted over the invention of a product. And the person who invents, who makes a product, is a patent owner. He or she can decide upon the usage. A person who invents a medicine can decide how the medicine will be used. The person is generally a scientist or a chemist, for instance. Then we have copyrights. You must be familiar with the word copyright because we often use it in terms of films, various music videos on YouTube. The right obtained over the creation of any literary or artistic work refers to copyrights. Often we hear that there is somebody sued for copyrights. This is mostly done because the person has copied somebody else's work. That's when the person is sued by the original creator. Books, films, scriptures, paintings, these are all falling under the category of literary works or intellectual properties which are protected by copyrights. Any other person who wants to make a film or write something or paint something based on another person's ideas, he or she has to seek permission from the original creator. Next, we have designs. Any design invented by a person shall be protected by designs. For instance, design of a biscuit wrapper, we have Bisque Farm, or suppose kids eat Oreo or other such biscuits. Those have their own designs. We can't simply copy the design and make our own product. We have to make our own things. We can't copy them. Or a cold drink bottle like Coca-Cola bottle, they have their specific designs. Design of a car, for instance. Geographical indication, the last thing of this chapter. Geographical indications refers to the fact that certain products, they have specific geographical origin, and those products also possess characteristics of the place from which they belong. So they possess characteristics that attribute to the place of origin. Like for instance, the best tea in India is said to be found in Darjeeling in North Bengal. So we are familiar with Darjeeling tea. That's a geographical indication. Tea from Darjeeling possesses qualities attributable to the place. That's why it's renowned. Or Tirupati laddu, the laddu that we generally eat when we go to the Tirupati Mandir in South Indian Andhra Pradesh. Such examples are about geographical indication. So you see, all these things are intellectual properties. These 5 things. And we come to an end to this chapter on property. I hope, this is a very easy chapter and it's very scoring too. You need to read this because it has some, 5-6 marks, I think. I will write in the description if you want to know. So I hope you liked the video. If you did, then please give it a like, or you can write a good comment, and please subscribe to my channel. Thank you so much. Bye.